Good afternoon. Today's Business Law Bootcamp presentation is titled Limited Liability Companies and Operating Agreements. Our presenters today are John Selbach, MacIlwaine, just butchered your name, and Clarke Bonney out of our Richmond office. Before we begin the presentation, I'll turn it over to David Cann in Baltimore for a brief introduction. Dave?
Great. Thank you to John, Will, and Clarke for putting this together for us. The Business Bootcamp series is intended to give broad background for both early stage corporate attorneys and also all our general practitioners on key elements in your toolbox. And to me, in the 21st century, knowing how to form and organize and start an LLC is absolutely essential. So this is a key program in this series. And our presenters today, I'll call them the magna cum laude team of John, Will, and Clarke, because that's what stands out between all three of them. Because John is coming on later, we'll have him introduce himself, but he really is the leader of our business law team down in Richmond in many respects. And Will has been working with him for more than a year now, and I know has worked on a number of different transactions, but also forming LLCs and the mechanics of their operation. And we're happy to have Clarke with us, recently joined us from Virginia Beach, and I can tell he has a good amount of experience, particularly in drafting operating agreements themselves. So we look forward to hearing from all three of you. And the only other thing I ask for you is to root for the Ravens this weekend.
All righty. Thank you very much. I'm Will MacIlwaine. This is my colleague Clarke Bonney, and today we'll be presenting on forming and organizing limited liability companies. So just as an introduction, LLCs offer substantial flexibility, and they combine the liability protection of a corporation with the tax treatment of a partnership. Now, LLCs are generally formed by just filing a simple certificate with the relevant state authority and the state of formation, and they're governed by that particular state's LLC laws. In addition, the members of most LLCs will enter into operating agreements, which in some states are also called limited liability company agreements. Those operating agreements or LLC agreements are generally used to document private agreements among the members of the LLC, or to supplement or alter the default rules in the respective LLC laws of the state of organization, which we'll discuss more about in a bit. Okay, so some advantages of LLCs. Limited liability is offered for owners, which are known as members. LLCs are easy to form. They're formed by a simple filing with the state. So in Virginia, that's through the Articles of Organization. In Delaware, for example, a certificate of formation is filed. Another advantage is greater flexibility in allocating profits and losses among the members. Additionally, there are fewer formalities than in a corporation. For example, unlike corporations, an LLC is not required to hold an annual meeting of its owners or provide for formal elections of directors and officers. Additionally, an LLC is not required to create and maintain the same governance documents as a corporation, such as the bylaws and the annual minutes and the resolutions that are adopted by corporation shareholders. Additionally, we'll talk more about this in a second, but pass-through taxation to avoid double taxation is also another advantage of an LLC, unless the members choose an alternative tax classification. So even though an LLC is a recognized type of business entity in the United States, LLCs don't have their own federal income tax treatment. So for federal income tax purposes, an LLC is commonly treated either as a disregarded entity or partnership, depending on whether the LLC is a single member LLC in which case it's a disregarded entity, or a multi-member LLC, in which case it will be treated as a partnership. However, LLCs may elect to be treated as a C corporation, in which case the LLC is subject to 2 levels of federal income tax. However, that double taxation can be avoided by electing to be treated as a partnership, which is a pass-through entity for the federal income tax purposes. So an LLC that's designated as a partnership does not pay an entity-level tax, and instead the profits and losses are passed through to the members who report and are taxed on their respective shares of those items on their own federal income tax returns. So obviously, clients would certainly want to discuss this and other tax considerations with their CPA or other tax advisor before making a final decision on how they'd like their LLC to be taxed. So just a few procedural things in regards to forming an LLC. Obviously, selecting a name for the LLC is one of the first steps, and as a preliminary step, the client's going to want to check to see if the prospective name they desire to use is actually available in the state of organization. Generally, you can just do this by going to the respective state website, and there's a tool to see if the name's available. Again, if the LLC plans to use this name for something else, such as a domain name, a trademark, or a service mark, the client might consider running a separate search, like a trademark search, to look for similar names in the marketplace that might already be in use. If the client's not organizing immediately but wants to reserve a name, you can do that to ensure that the name is also available when the entity is ready to be organized in the future. Second, selecting the state of organization is an important consideration. Obviously, Delaware is a very common state of organization, but there are other reasons for forming the LLC elsewhere. The reason Delaware is so popular is that it has a rapidly developing common law system governing LLCs, and it's a very established system as well. But practically speaking, like I said, there are other reasons that you might form an LLC in another state. Another popular state would be the organizer's home state. It's often the easiest and most cost-effective method for selecting the state of organization. So other formation considerations to keep in mind, obviously determining where the principal place of business is, as well as where the employees will be located, as well as determining whether the LLC will need to qualify to do business in other states. All right, the next consideration in forming an LLC is related to drafting the formation document. So like I said earlier, depending on the jurisdiction of organization, an LLC's formation document is going to either be called the Certificate of Formation or the Articles of Organization. In regard to the Articles of Organization, the most common practice is for that to contain a variety of statutorily defined minimum requirements, primarily including a few of the following, including the name, designated entity signifier such as LLC or LC, the address of the registered office and the name and address of the registered agent, the location of the principal office, the name and address of the organizers, and including all these things, the articles may also set forth other provisions as allowed by the respective state of organization's Limited Liability Company Act. Examples include a specific term or duration of the LLC, a business purpose for the LLC, and whether the LLC will be managed or managed. And for the vast majority of LLCs, additional provisions related to the governance and the conducting of the business of the LLC can be addressed in the operating agreement. So the operating agreement of an LLC is an agreement of the members of the LLC that governs the affairs and the conducting of the business. It has many purposes, and those include defining management structure, describing how profits and losses are going to be allocated and distributed among the members, and setting out other various agreements among the LLC members. In many ways, this is pretty similar to a sort of a combination between the bylaws and the shareholders agreement for a corporation. And the use of an operating agreement is especially important if the LLC has more than one member, because it can help resolve various disputes. There's no specific content that the operating agreement has to include. There's also no requirement that the operating agreement has to be drafted at all. And in most states, the terms of the operating agreement will control over almost all the statutory defaults, with a few exceptions, which we'll discuss later. provided in the Limited Liability Company Act of the LLC state of organization.
All right, a few of the considerations, major considerations need to take into account when drafting operating agreement. Is the LLC single member or is it multi-member? If it's multi-member, you need to think about things like how will the interest be divided amongst the members? And also, will the interest be represented by certificates or uncertificated percentages? Frequently, it can be uncertificated percentages, but some companies do like to use certificates that facilitate their bookkeeping. Will it be managed by members or by managers, which we'll discuss a little more next few slides? How may the interest be transferred after the operating agreement is established? How are other members to be admitted into the company, and how are existing members able to withdraw from the company should they choose to leave or otherwise go out on different terms? How are capital contributions handled? Very important. How are the profits and losses allocated or distributed amongst the members? Also, consider how can the LLC be wound up or dissolved should the members not wish to continue with the business? Who are the LLC's investors, and are any of the key employees also members, which could bring some complications in there. Also, what restrictions should be included to protect any proprietary information that's owned or possessed by the LLC? Very important to consider this. Brings me to the membership structure of an LLC. As mentioned, there are single-member LLCs, and if that's the case, then most of the considerations just discussed are essentially moot. But if it's a multi-member LLC, then the operating agreement should set forth, among other things, the processes for admitting new members, as well as the withdrawal of existing members, the voting rights for members for voting on the business and affairs of the LLC, and frequently the members would delegate the rights of their voting rights to the board of managers, which we'll discuss a little more next slide. Also, we want to include, will there be more than one class of LLC interests or not? With the flexible capital structure of an LLC, different classes can be created, which include non-voting interests, convertible interests, as well as profit interests, among others. Also want to think about if the members do retain voting rights, will they hold meetings to exercise these voting rights? And if so, they should consider other provisions related to that, such as annual special meetings, when will these be held, how will notice of meetings be given to these members, and whether the members may take action by written consent in lieu of having a meeting. Next up is the management structure. Unless otherwise set forth in either the Articles of Organization or the operating agreement, default is for an LLC to be member managed, but this is rare for an LLC to be member managed unless it's consisting of only a single member. A manager managed LLC is generally more appropriate where there are passive members in the LLC. This could be the case when the members are investors that are not actively involved in direct management or the day-to-day activities and business of the LLC. Managers that are appointed usually govern the LLC in a capacity that's very similar to the board of directors for a corporation. Appointing managers to board managers, you need to consider several things. How many managers will there be? Typically, you want an odd number to avoid deadlocks, but you can also have weighted voting to ensure that even though there are those even amount, there won't be those sort of deadlocks. What will be the powers of the managers, and how are they to be compensated for the performance of their managerial duties? And if they're not performing those duties, how are they to be removed and their replacements appointed? Also want to factor in, will they be able to appoint officers and delegate their authority to those officers to assist with the day-to-day business, like you would see with a corporation? Will the operating agreement include indemnification procedures for managers who face liabilities arising out of the course of the performance of their managerial duties? Typically, managers are indemnified to the maximum extent allowed by law, but certainly you can contract for less protections if that's the route you choose. Are there any limitations on the power of managers? That's one of the most important ones to consider when appointing managers. Matters that the members typically retain are the right to vote on the sale of all or substantially all of the LLC's assets, mergers involving the LLC, and incurring debt over a certain amount, and also dissolution and termination of the LLC. Now we get to capital contributions. Capital contribution is the payment a member makes to the LLC in exchange for its LLC interest. The percentage of which the member receives for that payment is a matter of negotiation between the parties. The operating agreement may state how the initial capital contributions will be made, whether such contributions are in the form of cash, property, services rendered, sweat equity, if you will, or other obligations of sufficient value to the company. We also want to consider other factors such as will additional capital contributions, which are capital calls, be required in the future to raise its working capital that the company needs. That's frequently the case. So if these are included, who determines when to call an additional capital contribution? It's often left up to the discretion of the manager, but it can also be left to the members as well. How are members to be notified of capital calls, and how much will each be responsible for when responding to calls? These should be set forth ahead of time to prevent any sort of acrimony or disagreement among the members. Finally, how can the company raise any additional funds that are not provided by the members as part of that capital call? If nothing is provided in the operating agreement, managers can usually seek outside funding, but it's all a matter of negotiation. Also involved with the capital call, the operating agreement may want to address a member's liability should that member fail to pay capital contribution. For example, we can have another member who did answer the capital call provide a loan for the defaulting member and provide a loan that gains interest until it's paid back. Related to capital contributions, allocations and distributions of cash flow to the company. The operating agreement state how the LLC's allocations and distributions are to be made between or among the members of the LLC, and these sections reflect the economic deal that's struck between the parties. Allocations, the LLC's net profits and net losses may be allocated simply according to each member's percentage of ownership or some other more complicated waterfall provision. Distributions are similar to the allocation of profits and losses in that way. They can often be made simply according to percentage of ownership or another complicated waterfall provision as negotiated between parties. If the LLC's manager managed, the members may also want to consider adding a provision making it clear whether the managers have the discretion to distribute the funds or whether such funds are distributed on certain dates, such as quarterly. Frequently, you'll want to include in the operating agreement a provision that at least requires the distributions to be made to members covering their tax obligations that are attributable to their membership in the LLC. And importantly, members should also consider placing restrictions on distributions. A frequent one is an LLC is usually unable to distribute funds if doing so, but leave the LLC unable to pay its current liabilities and operating expenses. John. Okay. I'll cover John's. Now, regarding the provisions governing transfers of interest, the operating agreement should specify the terms and conditions for admitting new members and any transfer restrictions on membership interests that are given. Unless the operating agreement provides otherwise, if a member transfers or assigns that member's interest, the transferee then has no right to become a member or to exercise any rights or powers of a member, and is only entitled to share the profits and losses of the company and receive the distributions and allocations of income, gain, loss, deduction, credit, or similar item to which the former member was entitled. If the LLC is treated as a partnership for U.S. federal income tax purposes, any transfer or withdrawal that would cause the LLC to be treated as a corporation for U.S. federal income tax purposes should be prohibited by the operating agreement, notwithstanding any other provisions contained therein. As to consent for transfers, the operating agreement should also address what consent would be required to permit these, such as requiring the consent of a majority of the board of managers or the non-transferring members, etc. Also, the operating agreement may want to address whether there are permitted transferees whereby the consent requirements would be accepted. For example, transfers to family trusts and or immediate family members for estate planning purposes may be made without any additional consent. Further considerations regarding transfers of interest. What types of transfer and buy-sell provisions will the operating agreement include, if any? Common examples of these are tag-along rights, which gives minority members the right to participate on a pro rata basis in any controlling member's sale of its membership interest in the LLC to a third party. drag-along rights, which gives a majority member wishing to sell to an unrelated third party all or substantial percentage of its membership interest in the LLC, the right to force the other members to also sell all or a portion of their membership interest to that third party. Right to first refusal requires a member receiving an offer from a third party to first offer their interest to the other members. Like the right of first offer, like the right of first refusal. This requires a member wishing to sell their interest to offer their interest to the other members first, and also their preemptive rights, which give the members the right to buy a pro rata portion based on their ownership interest of any future membership interest issuances that the LLC makes. The final considerations for the transfer of interest provisions. If buy-sell provisions are included, the operating agreement should also address valuation and payment methods for this interest to be transferred. You may want to also consider deadlock provisions. Common ways to deal with deadlocks include mediation or arbitration, the buy-sell provisions we just discussed, and a third-party referee outside of the legal process. Council should make sure that any buy-sell provisions or transfer restrictions that are in the operating agreement are consistent with provisions in the operating agreement that address the withdrawal and expulsion of members. Regarding admission of new members, including transferees of existing LLC interests, usually have to meet certain requirements before becoming a member for purposes of the operating agreement. Such as agreeing to be bound by the agreement and certifying that the new member is an accredited investor as defined under the Securities Act of 1933. If a transferee is not admitted as a member under the operating agreement, typically that transferee is only permitted to receive the economic benefit of that membership interest. Now we get the restrictive covenants. These are frequently included in an operating agreement to protect any proprietary information owned or possessed by the LLC. For example, is there a need for confidentiality provisions? An example of this would be if the company has trade secrets to protect, it usually wants its members to agree to maintain them as confidential. Is there a need for non-compete provisions? Members, managers, and other key employees are often restricted from competing with the LLC in the operating agreement. If the operating agreement includes non-compete provisions, should they apply to all members and managers? The restricting competitive activities of members and managers who are also key employees of the LLC is usually more important than restricting minority investors who have no involvement in the LLC's operations day to day. Now, as to dissolving and winding up an LLC, these provisions authorize the specific persons and processes for resolving all of the LLC's liabilities and obligations, closing business, and selling all of its assets. The operating agreement may specify time for or event of dissolution, as well as provide how the LLC may be wound up. Clients may also want to consider what member vote is required to terminate the LLC. Most often, consent of all or at least the vast majority of the members is necessary to terminate the business. Who will take care of winding up and the liquidation process? This is usually handled by the managers or somebody that the managers appoint to take care of. How will assets be valued and distributed in liquidation? After the LLC settles its debts and pays its creditors, any remaining LLC assets or proceeds from their disposition are often distributed to the members based on the members' positive capital account balances, or sometimes based on more complicated formulas. These formulas are often intended to be the same as those provided in the allocation and distribution sections, subject to certain enumerated exceptions.
All right, thanks, Clarke. All right, so the following are just a few miscellaneous provisions that you can consider including in the operating agreement. The first is determining, or I guess, what state's laws should govern the operating agreement. So it's pretty common just to pick the laws of the state in which the LLC is organized. Next is how will the operating agreement provide for resolution of disputes among the members or among the members and the LLC itself. Kind of going along with that, will the operating agreement provide for a specific venue or jurisdiction for the disputes? And how can the operating agreement be modified?
Go ahead. Keep going.
Okay. Let's see. So sometimes the managers of the LLC can make administrative changes to the operating agreement in their discretion, but All other changes typically will require the approval of a certain percentage of the LLC membership interest. Another consideration is how are notices made under the operating agreement. It's possible that some members would want to allow for notices to be made over communication such as email, while other members might prefer only hand delivery. You can consider adding a no third-party beneficiaries provision, which will make it clear that third parties don't have any rights under the operating agreement. Another thing to consider is, will the LLC interest be evidenced by certificates, similar to stock certificates? Clarke mentioned earlier, generally, the LLC interests are uncertificated that we see. If two or more parties are forming the LLC, it's important to make sure it's clear in the operating agreement that each party has been advised of their right to seek separate counsel in relation to their individual interests, and that they've been given an opportunity to do so as well. Finally, I think it's important to make it clear to the client, again, as we stated earlier, to have their tax advisors or the CPA review the operating agreement, especially in regard to the tax matters as well as the allocations and distributions provisions. Okay, initial acts of the members and managers. So while it's not required by most states, some LLCs choose to pass the initial resolutions of the members or managers of the LLC, similar to the initial acts of the board of directors of a corporation. If the LLC chooses to do this, consider passing organizational acts such as applying for foreign qualification in other states if necessary, applying for a taxpayer identification number or employer identification number if the LLC has multiple members, or any tax status other than a disregarded entity, as we discussed earlier. Obtaining any licenses, which can be state or local, that may be necessary to conduct the business of the LLC. Adopting the fiscal year, so LLCs generally operate on a calendar year. Opening bank accounts and authorizing signatories, and electing officers. So LLCs can have officers similar to corporations as well. The LLC should also address specific actions or documents that the members or managers may need to approve. An example of this might be an employment agreement. And if the LLC is being formed for a specific reason or as part of a transaction such as a merger, there may need to be deal-specific agreements and documents to also approve.
This brings us to our question portion. For any just generic questions, then we will end the broadcast and have more of a discussion afterwards. So any general questions on the subject matter?
Yeah, so you covered a section on planning for an exit strategy in a multi-member LLC. Is there a threshold where you're advising on that? So, you have 2 members, you have 3 members, at what point are you advising on that? Because obviously, from the perspective in which I'm seeing the LLCs, I oftentimes see it where somebody wants an exit and they haven't planned. So is that part of your standard practice now, as long as there's more than 1 member, to start counseling on that, or is there a threshold?
I would answer that probably in 2 ways. The first part of the answer is we try to talk about that. Assuming we form the company, a new client comes to us and says, form an LLC for me, we want to talk about that from day 1. And we will talk about the various ways people might want to leave an LLC, whether it's a sale of the company, whether it is somebody wants to retire, somebody just wants to get out of the business. Then that kind of leads into your discussions about drag along and tag along rights. So we basically have an entire transfer discussion, and we've actually built a grid out kind of a choice matrix for part of that discussion. So that's at the formation piece. Your experience, you highlighted, kind of goes to the second point, and that is somebody else formed a company, an LLC for somebody, and they come to you, here's what's going on. Unfortunately, usually the reason they're coming to us is because somebody's already brought a sale opportunity to them. And so we're kind of we are advising on their rights under the agreement. Anytime we pick up a new client kind of midstream and it's not at an exit event, to the extent we can, we encourage them to be planning for an exit event. And that's not just under the LLC, it's get your accounting straight, have your house in order, so to speak. Unfortunately, clients don't tend to do that ahead of time, to make things easier until they have to, for economic reasons. So we're constantly having those conversations. It's one of the most important parts of the LLC agreement. Sometimes that advice falls on deaf ears, and sometimes it's well taken. Does that answer your question?
It does.
Any additional questions from the other offices? Okay. If there are no additional questions, on behalf of White, Taylor, and Preston, thanks for joining us and end the broadcast, and open it up to more of a discussion phase.